Hi, today's lecture is going to be about contracts. This is the last lecture I'm going to give about contracts, and this one's covering enforcement, discharge, breach, and remedies. So let's get started. First of all, the area of contract enforcement deals with the discharge of contract duties, when there's a breach of contract, and what remedies you might get for that breach. So let's say you've got a contract. You feel it's valid, which means it had mutual assent, consideration, and it had the absence of legal defenses. How are you going to enforce this contract when you feel like the other party isn't performing? First of all, we need to understand the difference between a promise and a condition. Remember, you had to have that mutual exchange of promises? Well, a promise is a commitment to do something or to refrain from doing something. When that promise is unconditional, the failure to perform that promise constitutes a breach of the contract. So that's pretty simple. You promised to cut my grass. I promised to pay you $100. If one of us doesn't do as promised, and it's unconditional promise, then there's a breach. Now, a condition is a little bit different. It's a promise to do something, but that promise is conditioned upon some kind of an event or something that's going to happen. If that event or condition doesn't occur, then the promise doesn't need to be followed through with at that time. So if the event doesn't occur, if that condition doesn't occur, then it's okay not to perform the duties of the contract. So that's what a condition is. Sometimes you have contract provisions that are both a condition and a promise. In that case, those are just called constructive conditions. So you're just going to want to kind of remember that and learn that in your legal definitions and terms. All right, well, let's say it's not just a straight up promise, that we've got this condition and my performance hinges upon this condition being performed. So let's say let's say I'm a record company, and I say to you, once you sell 100 CDs or 100 copies of that song, then I will schedule you and you will get a concert venue at a really great stadium. Okay? But the condition is that you have to sell 100 of those songs. So what happens if I say, if you're saying, no, you told me that you were going to give me this big concert venue. And I can say, well, you haven't sold 100 of your songs yet. What are some reasons why that condition might not have been met? Well, number one, hindrance. If you are causing your album or your record or your music not to be sold, you're actually hindering the performance of that condition, that's your fault. And I can get really angry at you and I can sue you because I fully expected that you would be selling 100 records because I wanted to make money off of this concert too. But that was a condition. A breach. Anytime somebody doesn't fulfill their promise on any end is an excuse of the condition. This one's neat. Anticipatory repudiation is where you tell me, for example, well, you know what? I may sell 100 songs, and you can go ahead and schedule that concert, but I'm going to refuse to perform. So you're already telling me, you are anticipating that you are going to breach or repudiate the contract. I don't have to fulfill my terms. I don't have to promote that concert. I don't have to schedule it because I already know that you are not going to perform that end. Substantial performance will excuse the condition if, one of the parties has already substantially met their end. That's going to excuse the performance of the occurrence of the condition in order to enforce performance. A divisible contract is a contract, this is number 5, is a contract that goes in steps and stages. So say, for example, I'm going to sell 100 widgets in the month of January for $5 each. But then in February, I'm going to sell 100 widgets for $6 each. And then in March, I'm going to sell 100 widgets for $7 each. That's done in installments, and it's a divisible contract. So each one of those months is going to be looked at its own separate situation, and one of those months can be breached and the other months may not be. Anytime you waive the condition, you don't have to meet it. And if there's a estoppel, anytime you see that word estoppel, you know that that's that quasi-contract. Somebody's done something to their detriment based upon promises that they perceived. All right, another way to get out of a contract is to be discharged. Have your duties discharged. You can have the entire everything that you were meant to do in that contract. You can have all of that discharged, or you can have like a portion of it discharged. So how do you get out of some of the duties? Ways to discharge contract duties are performance. The contract was completely and fully performed. Illegal. It is then determined that some of these duties under the contract, or all of the duties under the contract, are really illegal. Therefore, there is no contract, so that would discharge people's duties under the contract. What if it's impossible? What if one of the contract duties said that you had to move into a certain house, but that house has been burned down? Well, now it is absolutely impossible for you to move into that house because the house no longer exists. What if it's impracticable? What if whenever you started the contract, you said that you were going to pay for all of the gasoline for somebody to drive across the country for an entire year, and at the time you entered into the contract, gas was $2.15 a gallon. But at some point during the performance of the contract, the gas prices went up to $50 a gallon. Well, that would just be impracticable for you to fulfill the terms of the contract. Another one is frustration or act of God. This is whenever, a tornado, wipes out whatever it is that you were contracting about. Rescission is where one party breached and the other party has the option of rescinding the contract and getting out of it, and basically saying, I don't want to be in this contract anymore. I don't want to fight it. I just want to walk away from it. Modification. Any time you modify a contract, during that time you can discharge people's entire duties or partial duties. Some more of them: substituted contract. You may have a current contract right now, but you can substitute it with another contract as long as all parties are on board. That can happen with no problem. That is very similar to novation. Novation is where there's a whole new contract. Novation generally involves a new party. A release is whenever, obviously it is what it sounds like, somebody either voluntarily is released or by the terms of the contract is released from doing certain duties. An accord in satisfaction is, let's say, for example, you owe the hospital $10,000. It's pretty clear that's how much money that you owe. You entered into a contract to pay that amount, but at some point, the hospital says, look, if you give me $6,000, we'll settle it, we'll call it a day. So that would discharge somebody's complete duty of paying $10,000 and reduce that to $6,000 under the accord and satisfaction idea. Account stated, that is simply where there isn't really a traditional contract. It's implied in contract. A lot of times they do this with credit card debt. You may not have a traditional contract with a credit card company, but because you used the credit card and maybe you have $3,500 worth of charges, once you pay those, it's over and your duties are discharged. Lapse is where perhaps you've let a contract term or some time period lapse or expire, and therefore you can be discharged from duties if that time period has already elapsed. And by operation of law, people sometimes can be discharged from their contractual duties if the law says, look, you don't have to do that. I know you agreed to do that under the contract, but you don't have to do that. Finally, how can somebody breach a contract? Well, it breaches, a contract is breached whenever a promisor who is under an absolute duty to perform doesn't complete or perform that duty. And the performance of that duty hasn't been discharged in some other way. There's a couple of different types of breach. The most important one, the one that's going to, you're going to see in lawsuits, is what's called a material breach. And a material breach is whenever one of the parties does not receive the substantial benefit of his or her bargain as a result of the other party's failure to perform. A minor breach is if the party receives the substantial benefit of their bargain, despite the other party's sort of defective performance. So let's say you hired somebody to build your house and to do the landscaping, and they built your house and was absolutely beautiful, exceeded your expectations, and they did the landscaping, but you wanted certain type of trees planted along the edge of your property, and they did everything except plant those trees along the edge of your property. That's really a minor breach. That is not a big deal. A material breach would be if they just didn't build your house at all, or they build it completely outside of the specifications. Also, you can have a breach whenever there isn't timely performance. Maybe it was expected under the contract that construction of your house would begin immediately, or that it would be done within a certain period of time, but the other party was not, for whatever reason, didn't start their performance in a timely manner, or they took far too long to complete the performance, and that could constitute a breach of a contract. So what if you've got a breach of a contract? What do you do? Well, there are certain remedies. You have to have a material breach by the defendant, and you also have to make sure that only one party breached. The plaintiff cannot be also at fault. If both parties are at fault, you don't really have any remedy. But you've got one party at fault. What are the different remedies? You can have compensatory damages, consequential damages, punitive damages, which are meant to punish, nominal damages, which are just a small amount, generally shown to show that one party was liable and the other was not. Liquidated damages, these are damages that were specified in the contract. They said, look, if this contract is breached by either party, the damages will be $10,000. They will have a specified amount in there. And the measure of damage is calculated in a number of different ways. And the idea is to make sure that the plaintiff is made whole again, but the plaintiff also has the duty to mitigate his or her losses. You can't just sit back and let your whole world fall apart because the other party breached. That's not right. You have to try to help yourself at some point. If you haven't attempted to mitigate your damages, the court is not going to look favorably upon that. Specific performance is another type of remedy. This happens infrequently, but it happens sometimes in real estate situations or where you have something that's unique, like a work of art. Somebody was supposed to sell you a specific painting or a specific statue, and they breached and they didn't turn over that specific statue. The court may order them to give that to you. That would be a specific performance. Same thing with a plot of land, anything that's unique or unusual or one of a kind. Rescission and restitution, this is where, look, the other side breached. I know they breached, but look, I just want to get out of this, so I'm going to rescind the contract, and the restitution is just damages to compensate me for any money that I had into this deal. Reformation is a way that you can remedy an error in the contract. This is something simple, like if there was a typo, the wrong date, the wrong name, the wrong something. And the court will order that this be reformed. The reformation, that just means that those typos can be corrected. In quasi-contract, this is just a definition. Again, it's not a contract at all. It's a legal fiction. In quasi-contract, if the court is just going to basically provide enough remedy for the plaintiff to make sure that they are compensated for whatever loss that they had, and also to ensure that one party isn't unjustly enriched. And in tort actions, those are a little bit separate. It's an improper performance of a contract can result in tort liability. There can be professional liability, which would be like medical malpractice or legal malpractice. And somebody can actually inflict emotional distress on another party by non-performance or by breaching a contract. All of those things can be combined with the breach of contract, the traditional remedies, and you can have more than one lawsuit side by side about the same transaction or occurrence. That's all I have for you today. If you have any questions, as always, do not hesitate to contact me. Have a great day.